So welcome everyone to tonight's constitutional conversation. I'm happy to welcome and thank Eugene Volokh, professor from UCLA, who's going to be the major domo of the panel. And I'm very happy to say, for those who don't know, that Eugene is going to be moving up to Stanford next year as a senior fellow at the Hoover Institution. He is one of the nation's leading First Amendment, Internet, and Second Amendment scholars in the country. So he's going to be a great addition to the Stanford constitutional world. This is a new thing tonight, and I'm really looking forward to it. This is the first one of our events of this sort at which the principal speakers are law students. So Chester Dubov and Graham Ambrose have both done serious, independent scholarship on issues having to do with the Second Amendment. And as I think most people who follow this field know, with the Bruen decision last year in the Supreme Court, the methodology for how to think about gun rights cases is completely changed and requires a lot more thinking. And so these two gentlemen are really in kind of the first take on how to make that work. And so I'm welcoming them and turning it over to Eugene. So please join
me. Thanks very much for inviting me up. Always a great pleasure to be at Stanford. Always a great pleasure to talk about Second Amendment. Even more of a pleasure to talk about Second Amendment at Stanford. And certainly there's a lot of room for scholarship these days about the Second Amendment. A lot of issues still to be resolved. So I think, Chester, you're going to be going first. So Chester will present 10 minutes on his paper, Graham 10 minutes on his. Then I'll have a few remarks and we'll have a bit of a conversation. I'll have plenty of time for a conversation with everybody else. So Chester, take it away.
Great. Well, first of all, thank you so much to Morgan, Professor McConnell, Professor Volokh, Graham, for all being here today. This is a real honor, and thank you so much to all of you for coming and attending this talk. I'm really excited. So my research into the Second Amendment was triggered by the Bruen decision, which came out in 2022, and my research centers on the methodology that Bruen lays out for how lawyers and judges are meant to analyze the constitutionality of state gun control laws going forward. So maybe a little bit of background on the Bruen case might be helpful. At issue in Bruen was a New York State concealed carry permitting law, which allowed the state of New York to exercise discretion in denying people concealed carry permits, even if they met other statutory criteria that would otherwise have made them eligible for getting those permits. And that law was ruled unconstitutional in Bruen. My paper is not really about the specific facts of Bruen, but my paper focuses on the new test that the Bruen decision announced. And what Bruen holds is that in order for a gun regulation to be constitutional, the government must demonstrate that the regulation in question is consistent with this nation's historical tradition of firearms regulation. That's a direct quote from the opinion. The opinion rephrases that as the government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. So what Bruen essentially asks courts to do is it asks courts, when looking at a state firearm regulation that a litigant is saying is unconstitutional, it asks courts to try to find historical analogs to that regulation. So it asks courts to try to look back into history and find something, something that shows that this law today is in keeping with our tradition of regulating firearms. And there are kind of two issues that my paper engages with there. One is, what history and tradition are we talking about? Professor, Justice Amy Coney Barrett, in her concurrence in the Bruen decision, identified that it's not entirely clear whether we are looking at evidence from the time of the founding or the time of Reconstruction in order to determine whether a law fits into America's history and tradition of firearms regulation. And so my paper makes an argument about how we should be thinking about that history and tradition. The bigger methodological question that my paper engages in is that the Bruen decision essentially says that the outer boundaries of the right to keep and bear arms is determined by the relevant laws that states had passed at either the founding or at Reconstruction. And anything that was not regulated back then is in a sense thought to be presumptively constitutional conduct, right? So if a state didn't outlaw some sort of conduct in history, that is taken as evidence that that conduct is constitutional and is protected by the right to bear arms. So the issue there is that the Bruen decision is essentially putting an enormous amount of evidentiary weight onto historical silence, right? It's saying that the absence of laws is evidence that whatever those non-existent laws didn't regulate, that is constitutionally protected conduct. And I think that we can see the flaws in this in this idea if we pose the question a different way. If we ask ourselves, instead of how far does the Second Amendment extend, if we ask ourselves how much power does a state have to regulate guns, how far does that power go, it is not logical at all to say that the state's power to regulate guns only goes as far as they happened to go at an important time in history. States regulate guns according to their police powers. And the police powers are the powers that every state government has to protect the health and public safety of the population. And these powers are vast. They are expansive. And at any given point in time, a state has more police power than it is choosing to use, right? California could ban all nicotine products tomorrow, presumably, if it wanted to. The fact that it hasn't today does not count as conclusive evidence that it doesn't have the power to do that. So just because a state hasn't regulated a particular piece of firearms conduct in the past should not be conclusive evidence that that conduct is constitutionally protected by the Second Amendment. And so if we are looking at history and traditions, we want to do this in a structured way, and we ideally want to take into account how Americans responsible for figuring out the limits of our constitutional rights, people like state Supreme Court justices or delegates at state constitutional conventions throughout history, how did they think about the right to bear arms? And my historical research points to a strong recognition, both at the founding and at the time of Reconstruction, that the right to bear arms was inextricably linked with the state's power to regulate public safety. If you look at state Supreme Court cases from the 1870s, the 1890s, the 1840s, that center on laws that people claim violated their rights to bear arms, and these were rights that usually came up under state constitutions, because the federal Second Amendment hadn't been held to apply to the states yet. The justices who write these decisions write about the right to bear arms and the state's police power to regulate firearms in often the same paragraph, often giving equal analytical weight to both the right and the state's power. And so my proposal is, instead of simply making a claim that the only power that states have now to regulate guns is how far they went in the past, we should be trying to figure out how to conceptualize the state police power to regulate guns with equal weight as the right to bear arms, and figure out a boundary that more closely reflects how these two forces have been seen to intersect in American legal jurisprudence. So I'm happy to take any questions about my research into state Supreme Court decisions, state constitutional conventions, or anything like that during the Q&A. But that is my contention, and the conclusion that kind of comes from this, other than the sort of methodological one about how we should be using historical evidence in figuring out the boundaries of constitutional rights, is that when we assess gun laws today, if we are doing it in a way that is faithful to how jurists and legislatures around the time of Reconstruction thought about gun rights, we should be thinking we should be putting far more emphasis on how we think states have the power to regulate those guns. And so states have more power than what they have simply done in the past, and we can't do as neat of a line drawing as the Supreme Court believes that we can. Thank you.
Graham.
Hello, can you hear me? Okay, awesome. So again, thanks so much, Professor Volokh, for being here. Thanks to Morgan, Professor McConnell, and the whole Constitutional Law Center for having us here today. This is, as Chester said, a huge honor. I'll be sharing a draft of a paper I'm working on about the history of gun making. And I really want to emphasize at the outset that this is a draft, which means that you were invited to push back, to mention things that don't make sense, or that you disagree with, or that are incomplete. I really do hope this is an exchange of ideas. So let's talk about gun making. The history of gun making has become relevant because of a new problem faced by states and the federal government, and that is the problem of ghost guns. Ghost guns have a lot of different names and definitions, but for our purposes tonight, they're homemade guns that lack serial numbers used to trace and identify the gun's maker or owner. These weapons are appearing in larger numbers due to advances in technology such as 3D printing. Today, anyone with internet access, a small budget, and a few hours' time can build their own fully functional firearm. And if you don't believe me, just type in "build a gun" onto YouTube and you will see thousands of videos. Prominent gun control organizations here in the United States call ghost guns the single fastest growing threat to public safety in America. And public authorities are cracking down, passing laws in just the last 5 years requiring a license or a serial number for people who make guns at home, and even banning some versions of homemade weapons altogether. Now, Bruen calls the constitutionality of these rules into question, as Chester ably explained. Indeed, plaintiffs have already begun to use Bruen to invalidate ghost gun regulations. Their lawsuits raise several questions. First, what is the history and tradition of making and regulating unlabeled weapons in the United States? Does the right to keep and bear arms encompass a right to make weapons? Already, the lower courts have split on these questions. So I spent many months diving into the history of gun making in early America, looking at statutes, court records, and treatises. And what I found surprised me. I want to talk tonight about two historical traditions relevant to evaluating gun making regulations under Bruen. So the first tradition I want to talk about is a tradition that's even older, even more widespread, and even more influential to early American history than gun making itself. And that is the tradition of gun importing. Yes, guns used by early Americans were seldom made by early Americans. Rather, the vast majority of this nation's guns used before the 19th century were manufactured in Europe. This can be seen from quite literally the very first days of English colonization of the Americas. The first Charter of Virginia, promulgated by King James I in April 1606, granted the settlers the right to import armor and munition needful to be used by them for their said defense. The 1620 Charter of New England and the 1629 Charter of Massachusetts Bay contained basically the same right to import guns. In the 18th century, imported guns were the primary weapon in both the 7 Years' War and in the American Revolution. Yes, Europe enabled our revolution by furnishing Americans with enough firearms to successfully wage a war. Even after the Revolution, arm imports continued through the founding and the War of 1812. Only by the mid-19th century were firearms made in large enough numbers domestically to arm the entire nation. Okay, so we were talking about gun making. Why are we talking about gun importing? Well, gun importing is important because it contextualizes something that's argued in a lot of these ghost gun cases, that the Second Amendment's plain text does cover gun making, because obtaining a gun is a necessary antecedent right to keeping and bearing guns. Justice Thomas came close to endorsing a version of this argument in a 2016 concurrence from a case called Lewis versus the United States about ammunition. In that concurrence, he said that the Second Amendment protects the right to obtain bullets. For now, let's just accept this argument, and that these antecedent rights derive from the plain text and not, a penumbra. Even if we agree that the right to keep and bear requires some sort of right to obtain a gun, it's just not clear that obtaining a gun requires making a gun. Here, the history is instructive. Before the mid-19th century, virtually all guns in America came from Europe. There's lots of evidence that early Americans thought procuring a gun was synonymous with importing a gun, buying it in foreign commerce, not synonymous with making a gun. There's just not good evidence that people at the founding associated the right to keep and bear arms with the right to make arms. Okay, so that was tradition number one, gun importing. Now let's talk about a second tradition, and that's the tradition of regulating gun making. Gun making was regulated directly and indirectly many times in many ways before, during, and after the founding. In my paper, I create a 6-part taxonomy for understanding these regulations. I have very limited time, and you will not be seeing all the evidence. Maybe we can get into it in Q&A. I would love to talk more. But just to give you a slice of the evidence. First, there's standard setting rules. These are public and private specifications for manufactured firearms, from their size to their compatibility with ammunition, to protect the safety of users and to improve their efficacy. 2, there's labeling rules, public and private requirements that firearms come with die stamps, engravings, markings, or other ways for authorities to be assured the gun's quality, its provenance, its owner. 3rd, there's licensing and inspection rules, which limit who could lawfully make weapons. 4th, there's labor rules, both public and private, on who can make weapons and when. 5th, there's public prohibitions on gun making by or for people deemed dangerous or people outside of the political community. And 6th, there's rules that control the making of gunpowder, an all-important and very explosive and flammable part of guns. So again, if you have more questions, we can get into specifics in Q&A. But for now, just suffice to say that this tradition of regulating gun making must inform the Bruen analysis. These regulations, I would also contend, cannot be understood in isolation. That is, we have to understand them in combination with one another. Together, they suggest a robust, if limited, power to regulate gun making. For instance, consider the sum of the powers to inspect arms, to impress gun makers, as was very common, to require gun labeling, at least in military weapons, and to confiscate arms. When looked at in combination, The use and existence of these powers establishes what Professors Will Bode and Robert Leiter in a forthcoming law review article in the Notre Dame Law Review call a legal principle. And that legal principle here, I would argue, is that authorities were capable of halting gun making upon failure to follow lawful standards, and were capable of directing at least some segment of the domestic manufacturing market to the extent that public safety demanded. Okay, so that was a lot of information. In closing, I want to just raise a few questions. The first is about incorporation. This picks up with what Chester was saying. Technically, the Second Amendment applies to the states only through the 14th Amendment, as Chester told us, which was ratified in 1868. And again, as Chester explained, the Supreme Court has really never addressed whether we're supposed to be looking at evidence from the founding, 1791, when the Second Amendment was ratified, or when the 14th Amendment was ratified in 1868, to understand the meaning of the plain text. Now, in case after case, Heller, McDonald, and Bruen, the court basically shrugged and said the distinction doesn't really matter for purposes of possessing a gun. Fair enough. But the gun-making question, and many other questions now being litigated in the courts, makes it much, much harder to punt this question. Of course, many in this room probably can imagine, and probably learned in high school history, manufacturing, industrialization, importing, domestic travel, shipping, guns, technologies, all of these things changed a very good deal between 1791 and 1868. Now, maybe that doesn't make a difference for the bottom line analysis. We can have that discussion too. But at minimum, if we care about the history, we have to really know what history we care about. Are we looking at the founding? Are we looking at Reconstruction? Some combination of both? The Supreme Court really needs to weigh in. Finally, let's think about technology. I know there are probably people in this room, certainly outside of this room, who see this whole history and tradition business as very abstract, very academic, and very removed from the real problem of gun violence in America. Indeed, the Bruen court seemed to acknowledge this when it said that modern technology requires maybe some creativity and some flexibility. Justice Thomas, writing for the majority in Bruen, said that when dramatic technological changes create a problem altogether different from a problem dealt with in the 18th century, courts need a, quote, more nuanced approach. Ghost guns would seem to be the very exemplar of a more nuanced approach. In the 18th century, lawmakers were concerned that guns were too costly and too difficult to make, and that a dearth of guns imperiled public safety. Today's lawmakers are concerned that gun making is too easy and too accessible, and that an overabundance of guns, at least in the wrong hands, imperils public safety. It's not a stretch to think that these problems are not the same because the technologies and the surrounding circumstances are not the same. Firearms in early America were imperfect tools. They were costly to build and buy. They required skill and patience to use. They broke very easily and very often, and they were incapable of causing rapid casualties. I love to remember that near the start of the Revolutionary War, Benjamin Franklin suggested that the troops use bow and arrows. Why? Because a really good person who could wield a bow and arrow could shoot off 4 before a musketeer could fire a single bullet. And again, there's so much evidence of how limited the technology was. The Federal Militia Act of 1792 required officers to carry a sword, just for context. This is all to say that how we define the issues we are talking about today matter a lot under Bruen. Before we can think of solutions or even talk about solutions to gun violence, we have to come to common ground about the problem it is we are addressing. So thank you, and I really look forward to question and answer.
Thank you. I wanted to give a few comments on each of the papers and hear your feedback on this. So Chester, so the great bulk of your article is focused on the Texas and Arkansas decisions following the Civil War, which basically allowed something close to a ban on gun carrying in certain kinds of situations, or in broad kind of situations. There were exceptions, I think, for travelers or for people on their own lands, but at least in many public places it could be banned. That's Texas and Arkansas. An interesting question is, why focus just in Texas and Arkansas? So the court's restatement of what it understood to be the understanding of the right to bear arms in the 1800s is more or less the following. Legislatures have a right to, or have the power to, ban concealed carry, because banning concealed carry still allows open carry. But they don't have the power to ban all carrying, because if you ban all carrying, that leaves people disarmed, at least in public. Now, it's true that Texas and Arkansas cases, the court acknowledges about Texas and tried to distinguish the Arkansas situation, are contrary to this position. But there are lots of cases, I'm sure you're aware of them, that fit very neatly within that position. In fact, in 1896, the court in Robertson, 1897, excuse me, in Robertson v. Baldwin, specifically mentioned, to be sure as an aside, in a case that isn't dealing with the Second Amendment, but I think that makes it even more powerful because it just sort of describes conventional wisdom. It isn't about kind of some fight about right to bear arms. It just sort of offhandedly says the right to bear arms is not infringed by laws prohibiting the carrying of concealed weapons. It wouldn't need to say that if it was sort of understood that the police power justifies all bans on carrying. No, it seemed to be reflecting this conventional understanding at the time that open carry was protected, or at least, let's say, some form of carrying was protected. Likewise, if you just look at the time you're talking about, right after the Civil War, sure, you have the Arkansas and the Texas cases. You also have, for example, the Tennessee 1870 Constitution, right around then, that says the citizens shall have the right to keep and bear arms for their common defense, but the legislature shall have power to regulate the wearing of arms. Not prohibit, but regulate. And there's at least good authority during the 1800s that the two are very different. Today, the power to regulate commerce is understood as including the power to prohibit it, but I don't think that was so then. Likewise, you look at Missouri, 1875. Right of no citizen to keep and bear arms in defense of his home, person, and property, or in the aid of the civil power, shall be called into question, but nothing herein contained is intended to justify the practice of wearing concealed weapons. And again, the implication, it's not the only possible interpretation, but I think the implication is, well, wearing non-concealed weapons is justified by the underlying right to keep and bear arms in defense of home, person, and property, but concealed is different. And that's just an example. I mean, 1875, North Carolina, 1876, Colorado, 1877, Georgia doesn't say concealed, but says shall have the power to prescribe, the legislature shall have the power to prescribe the manner in which arms may be borne, which is again to suggest that it can't outlaw the carrying of guns, but it can require that they be open, or perhaps require that they be concealed, as some states do today. So 1885, Florida, much the same thing. So I guess what I'm wondering is why are Texas and Arkansas so probative? Or the flip side is, if you look at the big picture, where Texas and Arkansas are on one side, and all these other things, including pre-Civil War state Supreme Court decisions that recognize a right to open carry. On the other, why didn't the court get it right in saying the conventional understanding in the 1800s was the right to bear arms, subject to the police power, to be sure, but the right to bear arms includes the right to at least open carry. The police power can go so far as to regulate the means of carrying, but it cannot go so far as to prohibit carry. So that's my question to you.
Yeah, thank you. So I think that my response to that would be about the kind of level of generality that my paper and my argument is operating at. I'm not arguing that there was some 19th century consensus that there was a legislative power to prohibit all carrying of firearms. I'm trying to, in my paper, I'm trying to reconstruct the way that judges, constitutional actors really interrogated the boundaries of the police power and the right to bear arms and how they thought about those two issues. Texas and Arkansas are particularly probative examples. First, because the Texas Constitution of 18, I believe, 69 and then 72, I think it is. It has similar language to a number of state constitutions that were passed in those decades. And Texas has actually a decent body of case law interpreting that constitutional provision. And essentially, what I'm arguing is that if we are doing a history and traditions test, if we are being honest about wanting to reconstruct the meaning of rights and the police power that we can find in the available documentary evidence from the period, we need to look at how judges actually thought about these things. And so it's one thing to point to constitutional texts that maybe by implication say some type of carrying is okay, other type of carrying is not. It's quite another to engage with documents where state Supreme Court justices actually had to decide a live controversy in front of them and were grappling with these questions in real time. So my point is really methodological. My point is about what evidence should count more when we're trying to figure out what a history and tradition of firearms means. And when we have a good body of case law on this from, say, Texas or Arkansas, then it's worth looking below the hood at the actual, at the actual decisions to see how the justices were weighing these questions to try to reconstruct how they thought about the boundaries.
Got it. So I think I see your point as to why you're focusing on court decisions rather than state constitutional text, although I would think that state constitution makers would be relevant to this. But why, again, Texas and Arkansas in the late 1860s and 1870s, when Kentucky court in 1822 reached a different result, to be sure, a bit of an outlier on the other side. It said even concealed carry was protected. Alabama Supreme Court said open carry is protected in 1840. Louisiana Supreme Court in 1850. Georgia Supreme Court in 1846. Looked like, in fact, the Tennessee Supreme Court may have said something similar as well in the 1870s, although it's an interesting question. And then if you go say, well, something happened in Reconstruction, you look afterwards, you have to go, say, 1902, the Idaho Supreme Court says, no, this is people have a right to carry. So again, if you're looking at state Supreme Courts, why Texas and Arkansas? Why so much focus on them and not on the other courts that reached the opposite result?
Well, I would say that, okay, so in the Alabama case that you're referencing, State versus Reed, there's an extensive discussion of the relationship between the police power and the right to bear arms, which I think is totally probative, totally worth investigating. State versus Andrews, I believe, is the Tennessee case that you're referencing. Similarly, a lot of discussion of the boundaries between the police power and the right to bear arms. A lot of pretty laudatory rhetoric about the legislature's police powers in these decisions. I believe you mentioned an Idaho case. That one, if I recall correctly, is more in line with Bliss versus Commonwealth, which is I think the Kentucky case that you're talking about. I'm not making a claim that there are easy lines to draw here and easy answers to come to. I'm simply saying that we need to do something slightly different methodologically than we have been doing up until now, and what the Supreme Court is seemingly asking litigants to argue in court. And so I take your point that all of those cases that you mentioned are relevant, and I agree that they're relevant. And I think that looking deeper at what those courts had to say and not just the sort of black letter law of what they held is really important for the Bruen history and tradition analysis.
Got it. Okay, thanks very much. So Graham, I have for you, I have just a bunch of somewhat smaller thoughts. One suggestion that I have is you talk about 3D printed guns. Maybe good to sort of highlight that as well, because this is of course a huge issue that's coming down the pike. But also reloading of ammunition. My understanding is that for many decades, a lot of people just as a hobby. Plus, also, I'm told, well, not I'm told, those are the shooting range in Boy, was 9mm ammunition expensive. I think a lot of people make their own ammo. So it would be an interesting question, especially as some states try to regulate ammo, to what extent there is a right to make your own ammo. And that is and that's partly also, I think, made especially significant by the fact that saying you can't make your own gun, there's still lots and lots of guns that are probably not much more expensive than making your own. Whereas with ammunition, it may be a substantial burden on people if you say, you have to buy your own ammo, especially if they're target shooting or something. But in any case, I just think that might be helpful.
Can I say something?
Yeah, of course.
Okay, so such a great comment, and someone in this room should write this paper for sure. My paper actually started as basically looking at gunpowder. There's been a lot of discussion over the last 20 years about gunpowder laws. It was brought up in Heller. It was brought up in oral argument in the Rahimi case that was argued just a few months ago. One just totally huge problem for any historian looking into these questions is that there were a lot of terms to describe the same thing, and there was one term to describe many things in the historical archives. So this is brought up in particular with ammunition. Ammunition meant what we would today call ammunition, bullets and the like, but it also meant sometimes, in some places at least in the colonies, it can mean the weapons themselves, munitions, think about that, but they'd also just call it ammunition. So when going through the archives, you see some people talking about ammunition, but what they're really talking about is the actual hardware. It's not helped by the fact that there were lots of different words to describe people who would make ammunition and who would make guns. So it's just one, sorry for the historical rant, one quick example. The historian Brian DeLay at Berkeley has made an essential point on a historian looking at this problem, and that is that there were three kinds of people who worked on guns before the 19th century. There were people who made whole guns, entire guns by themselves, which was probably a pretty small number of people, between 200 and maybe 2,000. There were people who made gun parts, so think of making just a gun lock. And then there were people who repaired weapons, and that was probably a huge number of people because guns broke so often. The problem is that all three of these were referred to as gunsmiths. You could be a gunsmith if all you did was repair weapons. You could be a gunsmith if you made weapons wholesale. The historical record is totally mixed, and historians have frankly not done the best job of teasing these things out.
Got it. So let me just quickly go through a couple more things, then we need to make sure we have time for questions. One thing is that the historical evidence that you give it is a mix, in part because history contains a mix. But some of it seem to be quite focused on particular things. Like, I think at one point you mentioned anybody who was making guns for the general public had to go through the process of proving, test firing a weapon, and marking it to know quality and safety. Well, all right, that may be sort of an early consumer protection measure. But the kind of manufacturing you're talking about now is actually specifically manufacturing not for the public. It's people making things for themselves. So one interesting question is, to what extent is the historical evidence that, well, we want to protect the public from unscrupulous distributors of bad guns, should bear on the question of somebody saying, well, I don't want to go to distributor of a gun. I want to make my own either through 3D printing or at home. A related thing is that you mentioned that colonial governments empowered to protect weapons for the war effort continue to specify firearms dimensions and other things. And this is an example. You give some other things. But again, that's procurement, right? That the state says, look, if you want to sell to us, you have to satisfy our standards. It doesn't tell us much, I think, about regulation of this as such. It's really more about, look, we want to make sure that we have good guns for our own purposes. Likewise, you were referring, this is not the same, you were referring to militia arms. It's an interesting question. I wasn't sure from context what it is, but if these were arms that you're supposed to bring to muster, again, you might say, well, that is kind of weapons that are being used for our purposes, it's your own guns, but part of your duty as a member of the militia. But that doesn't necessarily tell us much about what people are manufacturing. Another thing, this is a different matter that I wonder if it tells us much, is you refer to to what Charles I did in 1640 Charles I is doing a lot of things around 1640 that were not adopted as the canon of English liberty. In fact, if anything, we're part of the anti-canon. So it might be interesting to see if you have other evidence or if you can explain why that was seen as kind of part of standard legitimate government action and not the kind of thing that gets a king's head lopped off. So the broader point that I want to mention is I understand why your paper is focused on the history because that's the value added. But to me, it seems to me that as a textual matter, it's perfectly clear that the right to keep and bear arms does not, as a textual matter, protect the right to manufacture guns. It seems equally clear, without the need to go into at least the controversial form of penumbras, that the right has to include a right to access these weapons. The government can't say, oh, sure, you can keep and bear everything you want, but we're just going to prohibit all manufacturing and all selling and all importation. That can't be right. One way of thinking about it is there have been a few constitutions recently that have specifically protected abortion rights, as you may have heard in the news. Ohio Constitution. Every individual has a right to make and carry out one's own reproductive decisions, including decisions on abortion. I would say two things about it. One is it textually does not in any way refer to a constitutional right to perform an abortion as such, but at the same time, it surely has to have implicit within it some right to have access to abortions, which presumably somebody else must perform if it's a surgical abortion, and possibly access to chemical abortion mechanisms, which presumably someone would have to manufacture, right? So it seems to me that the right inquiry there is not so much history and tradition as the magnitude of the burden, which is something that Bruen leaves open, the possibility for. So it may very well be that we say, look, so long as importation is freely available and domestic manufacture is available, we can say you can't build your own, precisely because you can still keep and bear without building your own. Now, again, maybe that's not where your value added is. But my sense is, if indeed manufacturing restrictions have to be, in order for them to be upheld, have to be based on history and tradition, I'm not sure you've quite proven up the case, although you've provided some interesting evidence. I just think that they don't have to be based on history and tradition because they're not restrictions, manufacturing restrictions aren't restrictions on keeping and bearing. They are restrictions on something else, and so long as they don't substantially burden keeping and bearing, I just don't think that's a problem. So that's just my general suggestion. So I'll give you a moment to respond, and then we'll have Q&A, but you can respond more.
I will respond so briefly because there was so much there and so many wonderful comments. Very, very briefly, the kind of scope of this project was specifically to respond to courts that are adjudicating this issue. There's lots of kind of larger scholarly questions about what we should do, but some of these arguments being made in court right now, courts are split on the question, for instance, of whether the plain text covers. Some courts, to connect us back to the Bruen test, some courts say we have to do history and tradition no matter what. If it involves guns, going straight to history and tradition. So these are wonderful points, but my project was just kind of hived off at the court question.
Fair enough. All right, so we have time for conversation, so let's see who wants to converse.
Please come down to the mic here or over here. Turn this one on.
Hi, I'm wondering if, to address the problem of mass shootings and gun violence, we're not missing the basic point. If the court wants to freeze us back at the time of adoption of the Second Amendment in terms of the scope of the restrictions that government can impose, what justifies them allowing present-day definition of the term arms? I think the term arms at the time of adoption of the Second Amendment was single-shot flintlocks, swords, knives, clubs, axes, certainly not high-capacity assault weapons. And it seems to me dishonest for Thomas to say, all right, you're stuck with life at the time of adoption of the Second Amendment on what restrictions government can impose, but the definition of arms can be the modern definition, which includes nuclear weapons, stingers, whatever.
So I'm sorry. This is an interesting and important question that was discussed in considerable detail back in D.C. v. Heller. maybe if we have time, we can get back to it. But I'm hoping we could focus on questions that might be useful to these particular scholarly projects. It's just at this point, debating that, one could debate it, but I'm just not sure that it will advance these discussions much, given that that part seems to be relatively settled. Yes?
I have a question for Chester. You speak about the police force and the Second Amendment being very closely linked. And I'm curious if this is the case due to the right to regulate and maintain a militia that is possessed by the state, and therefore they have this kind of explicit right, or if it's because the citizens of a state have rights that ought to be proportionate to the police force of the given state. And I think this actually ties back to...
I'm sorry, just to be precise, you're talking about police force or the police power? Police force and police power are very different things.
I was... police power, yeah.
Oh, okay, got it.
Yeah.
Thank you so much. Yeah, so I know that Professor Volokh has written very, very persuasively.
Let's go on a first name basis. I'm calling you Chester. Call me Eugene. We're fellow scholars.
I know that Eugene has written extensively on the relationship between the well-regulated militia clause and the right to bear arms clause in the text of the Second Amendment. What I will say about that is, if you look at, I think there are kind of two answers to the question that I would offer. One is the Second Amendment's text itself and the texts of state constitutional amendments that predated the Second Amendment, enshrining the right to bear arms, almost always had some mention of some broader civic purpose or relation of power embedded in them, whether they were the militia or something about standing armies. And then later on, around Reconstruction, these constitutional amendments talk about the legislature can outlaw the dangerous practice of wearing concealed weapons, something along those lines. So there's something in the text almost always when we're talking about the right to bear arms that links broader ideas about public safety and security with the right to bear arms. And then secondly, there's something just about the police power that all states have, that states are just, by definition, tasked with securing public safety. And so whenever these issues come up, both as a matter of text in interpreting these constitutional amendments and as a matter of practicality in trying to figure out whether some gun regulation that a legislature has passed is constitutional, judges, whoever is debating it, are always debating the public safety dimension along with the sort of more heady intellectual, like, what are the boundaries of the right conversations.
So if I could ask a quick follow-up question. So there are two kinds of arguments that can be made about the relevance of the police power, which I agree is quite relevant. One is the police power is particularly present here because this right is related to the common defense. Sorry. And, it's true that that at least some of the pre-Second Amendment constitutions talk specifically about that. Mm-hmm. And some others, but some others, Pennsylvania and Vermont are examples, that talked about that, but also talked about people have a right to bear arms for the defense of themselves and the state. Then by 1792, it's the citizens have a right to bear arms in defense of themselves and the state without any military-specific reference later on. And then by the time we get to the 18-teens, 1817, every citizen has a right to bear arms in defense of himself as the state and the state. So it becomes pretty clear that to the extent that the right is in part national defense focused, it is also in part individual defense focused. So the other possible argument for the police power is it doesn't matter if it mentions the state. It doesn't matter if it's surrounded by discussion of standing armies. The police power extends to everything. The police power is the power of the legislature to enact laws that promote the health, safety, welfare, and morals of the people. And that's true as to speech, it's true as to arms, it's true as to anything. So I'm not sure which of those arguments you're making, or maybe you're making both. It's just that the first argument may not work as well by the time you get to Reconstruction, where a lot of the provisions are a lot more focused on individual self-defense.
Yeah, so I would say that thank you. That's a really good and perceptive breakdown. I would say that I am making both. And the reason I would say that it does matter what kind of surrounds the operative right to bear arms in these constitutional provisions, and what surrounds discussion of the right to bear arms in court decisions, because we're trying to, like, at the core, the court in Bruen is trying to give sharper definition to the boundaries of this right to bear arms. And if we are going to figure out what this right is, and we want to use history and tradition to get to what this right is, we have to be sensitive to the ways that important actors at either the founding or Reconstruction thought about this right, talked about this right, and we can make inferences from the language they used to enshrine it into constitutions and the language that they used to discuss it in judicial opinion.
But if that's so, then here's the complicated matter. They talk about in defense of the state, but also in the defense of themselves, or in defense of himself.
Sure.
So what does the fact that they talk about in defense of the state really tell us about the portion of the right that talks about in defense of themselves, or in defense of himself, or in some situation in defense of himself, his property, and I forget what else.
Well, I think one of the classic definitions of a first-rate intelligence is holding to perhaps contradictory ideas.
No, but there's nothing to suggest they're contradictory. It's that it sounds like they're talking about a right in defense of themselves, and a right in defense of the state. It doesn't follow that they need to be contradictory. But I guess what I'm wondering is, whatever the right to have guns in defense of the state must mean, what does that really tell us about what the right to have guns in defense of himself would mean?
I think that it means that the framers of that constitutional provision saw at least a dual purpose to the right, and we're currently, I think, giving a lot of credence to one side of that duality, the individual right. And my paper is not relitigating whether it is an individual right. I think actually the historical evidence shows that it is an individual right. I'm very convinced of that. But we need to give, if we're really doing history and tradition, I think we need to give evidentiary weight to the full formulation. And so we need to think about these broader societal focus implications of the right to bear arms along with the individual ones.
Got it. Yes.
Thank you. This is a question for Professor Ambrose. I wanted to ask, picking up on what Professor Volokh was saying about how your examples of licensing regulations, inspections, and so on point to a public safety interest, i.e. the guns were put on the market, whether you have looked into regulations on creating other products for self-consumption. And then, relatedly, I know, because I talked to you, that you've thought about some dormant Commerce Clause issues, but in those cases, Raich and Wickard come to mind. I think even in those cases, there's some suggestion that creating the product for yourself, it could interfere with the broader market, right? In Raich, the illegal marijuana enters the legal market, and in Wickard, the growing the wheat distorts the wheat market or whatever. So what is the hook to regulate something created for self-consumption?
Yeah, so that two really, really good questions. Let me address them in order. So first of all, just to be clear, the evidence about licensing, inspection, labeling, part of it is to protect guns that are being used on public markets. Part of it, though, is that gun makers were doing this on their own. They were labeling their weapons to assure its quality. Part of it was that, especially in the Revolution, the colonies and then states were telling gun makers, you need to put your label on it. And the purposes for this were not just kind of public safety, they were also often tied to property. You know, the government would confiscate arms and then want to give the arms back to people after, you know, the arms had been used. Part of it was also to kind of protect an individual, because remember, guns broke very frequently at the time, and when guns broke, they like exploded. You know, they chopped off fingers, they maimed people, they killed people. So it's both like the gun in market, but also just the use of the gun itself that kind of you needed to have some assurance of its quality, as well as that its maker knew what they were doing. To answer kind of the larger Commerce Clause questions, yes, that is a huge question. Basically, in to kind of summarize it, there's a lot of federal prosecutors really worried about ghost guns because they don't know how they can get jurisdiction over these things. I mean, if you sell a gun, it's easy for the Commerce Clause to kick in, right? Maybe, or if it transfers state lines. But if you make a gun just for yourself and you don't put a serial number on it, you don't have a license or anything like that, well then, yes, I mean, what is the way in which the gun is really affecting commerce? This has not really been litigated. It's kind of an open question. Frankly, I'm not really sure myself. I think this is another paper that needs to be written, and that's, I think you saw a draft of another paper that kind of deals with a related question. But the paper that I'm dealing with right now is really just the Second Amendment.
Yes.
Yeah, I was kind of wondering, so when you were talking about what the founders kind of viewed, and people talk about assault weapons and everything, I'd first like to use a journal entry and just point out a factual inaccuracy. And after saying that, I'm curious about how that changes your opinion of what the founders were doing. Because the Lewis and Clark expedition was equipped with a weapon that held about 20 shots, 50 caliber ammo. It was lethal at rifle ranges. It was also sold to civilians.
Louder, please.
Sorry. It was sold to civilians. It was invented in 1779. It held over 20 shots. In 1803, there was a journal entry where a man said, "I visited Captain Lewis's barge. He showed us his gun, which fired 22 times at one charge. Lewis showed it off to most of the tribes that they visited on the expedition. Over 39 times was it mentioned in his journal. Semi-automatic fire. It was really effective in the Austro-Turkish War. There's one on display in the Pentagon. There's other semi-automatic assault weapons from the time. And I'm kind of curious on, do you think the founders were thinking of those? Because I know that the Congress that equipped the Lewis and Clark expedition was made up of a lot of founders.
So let me ask you to quickly respond, and then we'll have time for one more question.
Okay, great. So surely, I mean, some weapons at the time were more effective than others. The research I was really looking at and was kind of the standard weapons that were being used in the militia at the time. These were the kind of weapons that were, by law, people were required to carry. And these were all some of the most common weapons at the time. If I suggest anything to the contrary, I don't mean to misspeak.
Like Hellier common use basically is your basis?
I'm sorry, I just couldn't hear what you said.
Like the common use clause under Hellier is kind of your basis?
Heller, the common use.
Sorry.
Oh, yes, sorry, excuse me. Yes.
Yes, last question.
Okay, thank you. My name's Dave Paul, private citizen. This is a great event. I think we need events like this because we need to increase the role of intellect at the expense of emotion in our political process today. It's essential. Now, in terms of dual purpose, everything before the comma is fluff. It's after the comma that is the telling part. The right to keep and bear arms shall. Now, today, we live in a very complicated time. Yes, there's going to be issues that come up that there's no perfect answer to. But we do need to be mindful of some basic principles. Just because somebody has put their hand on a Bible and sworn to defend the Constitution doesn't mean that oath meant anything to them. So we never want to look to government to totally assume control over anything at the expense of the individual, because you become deluded into thinking, as we see today, that you need a license, some type of degree to know anything.
You know, I'm very sorry, just time is short, and the goal is to make it helpful to the presenters. So if you can point to a particular thing in like one of the arguments that this bears on?
Just keep in mind that the telling part of the Second Amendment is post-comma, that the right to keep and bear arms shall not be infringed. And we need to be mindful that police power and citizens' rights should go together.
All right. So if I could maybe recast that question for you, Chester, I think this may be informed by this. So you're right that the court has focused on the self-defense function of the Second Amendment. And I think that even the justices in the majorities would say, you know, we acknowledge this was not by any means the only function, perhaps not even the primary function. It's just the one that kind of came to us. But there was this whole notion that, yes, there is this right to keep and bear arms in defense of the state. Interesting question, why that should be a right. But it sounds like probably it's a right of individuals because we want them to be able to deter government oppression, just as the English had done in the 1600s, at least conventional was, and just as the revolutionaries had done in the 1700s, again, conventional wisdom was. So therefore, yeah, there is this independent right, maybe more important to the framers than the right to keep and bear arms in defense of themselves. It's the right to keep and bear arms to defend the state, perhaps against the government, or defend the country against the government. But the question is, how can that be operationalized into actual doctrine? Did any of your sources tell us anything about that?
I'm not making a claim on how that is going to be operationalized. I think that my sources indicate a rebalancing of historical evidence versus what the Supreme Court is asking us to do. And my sources are indicating that saying that the state's power to regulate conduct stops where states have chosen to do it in the past is not supported by the evidence.
All right. I think we're done, but we have time to discuss things further. I think there's a reception after.
Yeah, so thank you very much. Please join me in